Good afternoon and welcome to this, our first residential property forum of 2024. I'm Robert Kelly from Stewart Title, and once again we're very pleased to see so many of you here, and also pleased to see that our resident residential expert Ian Quayle is joining us today.
Good afternoon.
So good to see you, Ian.
Good to see you, Robert. Good to see you too.
Ian will be addressing some of the questions that have been raised by you since the last forum, also looking at understand some new case law which has occurred, to talk about that. And in addition, we'll be joined by Aidan Moore from Metro Bank, who'll be talking about some of the services which they can offer to help help law firms and the ways in which they can smooth the transition if you want to look at changing your bank accounts, which is always a great problem for law firms. As always, this is your forum, so please contribute, put comments in the chat box, raise your hand if you want to, and Ian will try and address the issues and talk there. The dialogue is very important. We value this communication with the property industry, I think, as much as some of you do. Stewart Title is, by its name, a title insurer, so we only do property. That's where we come from. That's where we make our money. Like you, our success is in property transactions being completed and you getting paid and us getting paid. So we do see ourselves very much on the side of you as a partner. These sessions and the webinars, and we'll be holding some more webinars during the course of the year, are an important part of that. But equally as important, if you have a question about title insurance, you come against a title issue that you think may have an insurance solution, please get in touch and we'll try and help you. So enough from me. Lots of you are attending, showing a good New Year's resolution. So before that evaporates, rather like my dry January, let's get on with the questions. So Ian, please start.
Thanks, Robert. Thanks very much indeed, and welcome everyone. Again, huge thanks to Stewart Title for organising these events. As Robert was saying, we've got a series of webinars lined up over the year. Robert, we've got a series of conferences as well. I think the first one is in Norwich, another one in Ashford in Kent. So Stewart Title have organised and assisted with regard to sponsoring those events, face-to-face events, which are interesting. And of course, the support for the forums is brilliant. And again, a massive thank you to everyone attending today. The way today will work is that we've had some questions sent in. I've got some cases that I want to look at. I want to have a chat with Aidan from Metro Bank about what he's doing and what they're doing, because I think that would be really interesting. But you're more than welcome, if you've got any burning issues or burning topics, to put them in the chat facility, and we will deal with them before we finish. I know Robert and I were talking just before I started today, and he mentioned, guess what, the Building Safety Act. Three things to mention on that front before we start. Firstly, Cranfield Chambers on the 7th of February have organised a conference in London. I will be attending that conference. There are some spaces left, which is a day on the Building Safety Act. Yes, a whole day on that topic with lots of different barristers, including Andrew Butler, Casey, and a number of others, putting their input into where we are with regard to the Act, number one. Number two, the Law Society's guidance with regards to the Building Safety Act is due out imminently. I was hoping today to be able to tell you when it's going to be out. I can't as yet. All I can tell you is, because of the work we're doing with regard to a book on the Building Safety Act, I'm hopefully going to be told when it's going to be released, sort of when the guidance is going to be released. I've also been told that what we've said in the book with regard to what is best practice is very similar, if not the same, to what the Law Society has been or is going to suggest. A huge sigh of relief on my part, on the basis that I was terrified that what I was recommending in the book would be inconsistent with the Law Society. But touch timber, I think we're all right on that one. But I'll keep you in the loop. We may be able to deal with some BSA questions before we finish today. I'm going to talk to Aidan sort of halfway through the presentation, but before I do that, I'll just put this slide up. Just giving his contact details and telephone number. I'll put that slide back up when we're talking to Aidan, of course. Again, as far as useful websites are concerned, do have a look at all of these websites. I was doing some in-house training last week, And the firm was amazed that the RICS had sort of guidance about surveys and valuations, and was also amazed that the Association of Residential Managing Agents had some information about estate rent charges, which they do. So do have a look at all of those sites. They're really useful. Property Law UK is sponsored by Stewart Title. It is a monthly publication that is an electronic publication. It is a subscription service. If you send me an email, I'm sure we can send you some details. And we may, given it's dry January and we're celebrating Robert's absence from alcohol for the month, we might be able to offer you a bit of discount. Zara, thank you. Fire safety guidance on the RICS website. Haven't seen it. Thanks for pointing that out, Zara. That's brilliant. So topics for today then. What have we got? BSA update I've given you. Again, I'm still being asked by lots of practitioners about what happens. I've got to insist on a landlord producing a landlord certificate. You don't. And a lot of people saying to me, I've got to produce a leaseholder deed of certificate to the landlord. You don't have to volunteer it. Again, important that you understand that despite the government guidance, despite the actual certificates themselves indicating that service is necessary, etc. In fact, it isn't. So anyway, big case law that we need to have a look at, I think. The first thing that I mention is swooping up clauses in residential leases. Have you seen 89 Holland Park Management against Dell and Dell? This was a case that first sort of crossed my desk, and I think, Robert, you were instigating this, a connection with Tim Calland of Maitland Chambers, who was counsel in connection with that case concerning a restrictive covenant and an issue with regard to enforceability of restrictive covenant. That litigation, I think, ended up in the Court of Appeal. It led to a huge amount of legal costs being transmitted into service charge. And then there was litigation, which is what I'm talking about here, where the management company was being was subject to an action by some of the leaseholders in the property who were unhappy with the amount of legal costs that had been incurred in connection with that litigation, which had then been transmitted into service charge. And I've just been looking at that case sort of quite recently. It's a Court of Appeal decision that was handed down just late in 2023, and is really interesting because the court had a look at a number of things. First of all, swooping up provisions, and emphasised the danger in landlords relying on swooping up clauses, and highlighting a point that I frequently tell practitioners about, that rather than as a landlord relying on a swooping up clause in a residential lease for service charge, better to provide a list of the sorts of service charges that will be provided and the sorts of costs that are then recoverable, emphasising legal costs. So you can't provide within a lease for every conceivable type of cost that you could incur and sort of specify what they are, but you can, in general terms, refer to the types of management costs that you are aiming to recover, or the types of legal costs that you're aiming to recover. And I think the case of 89 Holland Park sort of highlights how sort of encompassing you've got to be with regard to provision. So in this case, what happened was the management company was attempting to recover the legal cost that had incurred in the restrictive covenant proceedings from leaseholders, relying on a sweeping up clause to employ surveyors, builders, architects, engineers, tradesmen, solicitors, accountants, or all other professional persons as may be necessary or desirable for the proper maintenance, safety, and administration of the building. Well, the Court of Appeal had a look at that and said, well, yeah, maintenance, safety, and administration of the building wouldn't necessarily include litigation costs concerning the enforcement of a restrictive covenant. So the idea here was that there should have been some reference to legal costs being made, to being incurred, and the types of action that could be encountered for which legal costs could be incurred and then transmitted into service charge. And then, in addition to that, there's another clause in the lease, without prejudice to the foregoing, to do or cause to be done all such works, installations, acts, matters, and things as in the reasonable discretion of the lessor may be considered necessary or advisable for the proper maintenance, safety, amenity, and administration of the building. So what the landlord was saying is, we're doing these costs well, we're doing this work, and therefore we're incurring these costs, and therefore these costs are recoverable. And the Court of Appeal was saying, well, unfortunately, that's not going to be the case. It's what you've got there isn't wide enough to include these legal costs. Management company then started arguing about, well, there's an estoppel. Mr. and Mrs. Dell were aware of what we were doing with regard to litigation. Because they were aware of what we were doing, they're liable for the cost that we were incurring. And then finally, the management company was saying, well, these are reasonable costs, reasonably incurred and reasonable in amount. And the Court of Appeal wouldn't have any of that either. So it's a really interesting case, well worth looking at. There is going to be, I think, an article in Property Law UK this month on that one. If you also go to Tanfield Chambers, there's a good note about the case, and you can also, there's a link to the actual decision itself, which is well worth a look at. So do have a look at that. It's quite an interesting case. Mackenzie and Chung, Court of Appeal decision, excuse me, in dealing with enforcement of restrictive covenants. I'll just dig up my notes on this case, because this again is another interesting one, to be honest with you, because what you had here was a situation which is quite commonly encountered, where the developer of a site imposes restrictive covenants, but then in an effort to get round the sort of notion of a building scheme and to retain control with regard to the site, the developer is basically saying, well, I'm enforcing restrictive covenants, but I'm reserving the right to agree with future owners about changes to those covenants. I want some flexibility with regard to that, was really what was the argument in this case of Mackenzie against Chung. So the citation is on the slide there. And again, it's quite an interesting case concerning a property called 43 Selsdon Road. And it concerned a developer that had bought the site and intended to carry out works, and a dispute with a neighbour who was attempting to enforce a restrictive covenant that prevented development. Now, the matter went to trial, went to application for summary judgment, and at summary judgment level, a deputy DJ construed the provision that was in dispute to mean that the vendors had no obligation, when dealing with subsequent conveyances of the retained land, to impose restrictions in the terms of the third schedule, which were the restrictive covenants. So the matter went on appeal before His Honour Judge Miles, who said that in essence, what was drafted was sufficiently worded to facilitate a waiver or release of restrictive covenants entered into in connection with land that was to be sold, and also land that had already been sold. And he looked at the wording, and the interesting thing about this case is the judge looked at the wording of the restrictive covenant in question, but looked at other restrictive covenants and sort of interpreted the wording, not just on the wording of the covenant in question, but the wording that was used in other covenants too. So it's really a really interesting case. There was another or some argument about derogation from grant issues arising with regard to the leasehold property that was being sold. Really interesting. Do have a look at it. Right, so I've mentioned that one. And then IAA Vehicle Services Limited and HBC Limited, which is a January case, reported in the Estates Gazette this morning concerning option agreements. So I'm just going to take you through my notes on that and just let you know what this concerns, because it's quite an interesting case. Option agreements are always interesting, aren't there? And we've got loads and loads of cases concerning option agreements over the years. But in this particular case, what you've got is, first of all, some issues about interpretation. You've then got some issues about the mechanics of entering into the option agreement and issues associated with the deposit, etc. And in addition to that, some interesting views with regard to, I'm just trying to find the case again. I've just lost it. I found it and then lost it again. Some interesting points with regard to the sort of drafting of an option agreement. So again, I'm producing some case notes with regard to that. If you're interested, I'll happily send them to you. But it just, one, affirms some old decisions with regard to interpreting commercial property documents. Two, highlights the significance and importance of issues associated with payments of deposit, and also just sort of provides some interesting insight into the interpretation of option agreements. So do have a look at those. Okay, so moving on, Zara raises an issue, the updated leasehold reform bill. Zara or anyone else, anything interested in that? I keep looking at the leasehold reform bill and see two things. One, are we going to do anything with regard to protecting freeholders as opposed to leaseholders with regard to estate rent charges? And two, is there anything sort of thrilling in the leasehold reform bill that means we're going to have some radical changes to what we're doing with regard to leasehold conveyancing? And I think the third point to note is really, is the leasehold reform bill an indicator that the government is sort of moving away from the relaunch of commonhold? I certainly hope so. So Zara, any points about the updated leasehold reform bill, or are you just drawing to people's attention the fact there is something worth looking at? Zara, you can either put in the chat box, or I'm sure we can enable you to speak. Just drawing to people's attention. All right, thank you for that. Good. Okay, so let's have a look at some of the other issues that I've got. The Law Society, big changes to shared ownership. Well, that's your bag, isn't it, Zara? So any sort of comments about the big changes to shared ownership? Could you, Zara, this is imposing on you, but sort of produce a little summary for us at some point with regard to the changes, once you've sort of had a more detailed look, or perhaps we can work together and work something out on that. Yeah, a summary would be useful, and happy to sort of look at that. Anyone else seen what Zara's mentioning? Okay, thank you, Zara, for that. Yeah, Law Society, Exchange Code of Practice. Has anyone looked at this? And anyone thought anything about it? First of all, have you seen it? The Law Society's guidance on exchanging contracts, the draft code for signing and exchanging property contracts, first edition, 2024. Who's seen it? They're living in Barbie land. Okay, Zara, yeah. Is that the Law Society, or is that a comment with regard to shared ownership, Zara? Yeah, TLS. All right. Okay. Yeah, fine. So who has seen the draft code for signing, exchanging property contracts? Okay. Number of things really that I think are really interesting relating to it. First of all, as far as the adoption of the code. Again, what you've got is parties to a conveyancing transaction being required to agree to comply with the code in relation to the particular transaction, to confirm this to each other in writing, by email or hard copy correspondence. And a confirmation is an undertaking by each of these solicitors that they will comply with the code and perform their respective obligations under it. And solicitors that are accredited the Law Society CQS scheme are required to comply with the code as from a date in 2024. You can adopt it earlier if the parties agree to use it. First question to everyone, do you know anyone that has actually indicated using it? I haven't as yet. Next thing, as far as the code is concerned, the parties' solicitors are, before signing, required to confirm that they've agreed the text of the contract, including additions or variations, the deposit, whether deposit money is to be remitted to the seller's solicitors or elsewhere, media to be used for the contract, wetting paper originals signed in separate parts, particular electronic format or platforms such as PDF, DocuSign, etc. So here we are once again seeing the tide of electronic conveyancing slowly creeping up on us. Have you seen this? So the idea is that we can agree an electronic format to be used for the signing of the contracts, for the method of effecting exchange of the contracts, and for steps to be taken after exchange. So theoretically, we're going to have a sort of electronic process for exchanging contracts. Really interesting stuff, isn't it? Now, the next thing that I think you need to understand with regard to this, it is, Hayley, it's a draft code at the moment. I think it's still out for consultation. And my parting gift with regard to this is I don't know when it's going to become live. Okay, so it's nothing to be worried about, Hayley. It's just a question at this moment in time of drawing your attention to it. Okay, and just highlighting the fact that there is the opportunity for this exchange of contract process to be undertaken electronically, as well as the use of electronic signatures. Yeah, okay, thanks for that, Hayley. So I'm taking it that no one's really looked at this or had a look at it and see how it works. I don't know if any of the sort of software companies, search providers, etc., have done anything. Yeah, Landrush already requires to pre-agree e-signing. They do. Yeah, you're quite right. Thanks very much for that. Yeah, and I think it's good practice in any event, isn't it? It's draft at the moment, but they're formalising the hold to order process. Yeah, Zara, I've got that. Are they hoping it will stop conveyancers getting clients signed up on draft and approve it at the outset and then refusing to accept amendments? Probably, Orla, probably. But as I understood it, the idea was that we need to update the idea of telephone exchange. So I thought that was the heart of this. I thought the electronic signature bit was just catch up with what people are doing anyway. And then I thought what we had now was the opportunity for an electronic exchange rather than a telephone exchange. And all certainly, I think they are hoping it's going to produce some of the problems. Zara, you're waiting for a solution to InfoTrack. But yeah, at the moment, it still does need to be done by phone, doesn't it? Yeah, thanks for that. It's interesting. I mean, you know, the idea of a telephonic exchange is archaic if you think about it. Okay. Again, however, there is an argument that, you know, how many pieces of litigation have you seen concerning an exchange of contract or what's said during a telephonic exchange? I don't think I've seen any litigation in all my years concerning, well, he said that or she said this or we varied that, and the other side saying, no, we didn't during an exchange. So let's just have a look at this. Zara, yeah, I agree that the tech isn't, I would say, robust enough to go completely digital. And when you see some of the things we've seen with regard to systems failures, etc., it becomes more and more terrifying, doesn't it? Hayley, the problem with agreeing is what happens if someone doesn't agree? Well, yeah, you've both got to agree, Hayley. So until there's sort of an acceptance of the process, we've got a problem, haven't we? Yeah, and the formulas, the telephonic exchange, and all that goes with it, Hayley, remains until you and I, if we're exchanging contracts, agree to adopt the code. Now, first things first, it seems to me that a lot of people aren't familiar with it. Secondly, those that are familiar with it are saying, well, yeah, we're not doing anything till we know that we've got a date when we've got to use the system and the process. And yeah, the post office scandal, indeed everything else. I was thinking, Zara, more of the problem that we had with regard to some tech causing problems with regard to bank transfers, etc., and case management systems, those sorts of failures, meaning that, you know, hey, have we got a backup system? Or B, what's wrong with what we've currently got? Right. Yeah, some solicitors still don't like email. You're quite right. Megan, PSL community points out new code needs a default option. So what if they forget or fail to agree? Megan, you're right. Yeah, that's something, isn't it? You know, and again, it's all right saying, well, to be CQS compliant, you've got to agree to this until you get sort of the heavy lifting done with sort of firms and lawyers saying we're willing to accept and willing to go with it, then I think, you know, it doesn't matter. Those looking at blockchain, oh, crikey, Zara. I haven't even looked at that, to be honest with you. Has anyone else looked at sort of using blockchain? I think, is it PEXA are looking at blockchain systems and one or two others? Yeah. And well, I tell you what, Zara, if you find an idiot's guide and then can write a Janet and John version of that for me, that would be brilliant. But at the moment, I'm not looking at blockchain or anything else. Again, interesting. I tell you what was interesting the other day. Someone was telling me about Bitcoin and using Bitcoin for transactions. Anyone sort of biting on that? I know one firm in London. Robert and I know one firm in London that is sort of very switched on to using Bitcoin, etc., for transactions. But has anyone else seen it or used it, or any firms sort of willing to proceed with regard to Bitcoin being used as for purchase price, etc.? Anybody? Yeah. Okay. Right. It uses. Thanks, Mark. But Mark, have you had any transactions where Bitcoin has been used, or is anyone else? As I say, I do know one firm in London that switched onto it, to be honest with you, and I think they were marketing themselves as being able to undertake transactions using Bitcoin. Might be interesting to get them along sometime and see what they say. Yeah, I know a lot of the youngsters, Mark, are sort of keen as mustard, aren't they, with Bitcoin? I'm still not sure. All I read about are the sort of horror stories, which perhaps means I've got a very negative view concerning it. Anyway, okay. So while we're waiting, so anyone else got any more topics? I've got a state service charge to look at, but what I'd like to do before I do that is introduce Aidan and to have a chat with him about Metro Bank. But before we do that, let's have a look. Right, no lady who set up a law firm and is trying to peddle this. Yeah, Zara, okay. Yeah, dangerous, certainly, from money laundering. Ola, you've come across a firm in Bournemouth that did that, okay. Zara's responded to the ground rent consultation. All right, Zara, just tell me quickly about that and then we'll talk to Aidan. Oh, all right, okay. So you haven't got a good result of your involvement in that. Yeah, all right, we'll put the microphone on for you. If anyone, Freddie, can you do that for Zara, please? And we'll hear about a ground rent consultation, which doesn't appear particularly positive. But if we can put Zara's microphone on. Hi, Zara. Zara, what we might do is we might come to you afterwards. Ground rent reform consultation for existing leases, possibly removing all rents. All right, so sort of give effect. All right, Zara, no problem. Megan, so right. And what's your view, Megan, on that? It makes sense, doesn't it? The only problem, I see with this is that what I'm seeing landlords and developers doing is saying, well, all right, in the past, we would use ground rents and revenue from it to sort of supplement service charge where we're not getting all our service charge in, where there are items of expenditure that we can't recover within service charge. Our ground rent revenue generates a sort of a cushion for us. And therefore, what they're saying is we don't have a cushion anymore. So what we're going to do is be imaginative with regard to service charge and charge management fees or fixed fees within service charge to recoup, or in essence, rename what was ground rent historically. Zara, they gave 5 options, but none of them is ideas. They will get sued. Yeah, okay. And you've got your microphone on. Right, thank you, Zara. So fire away, Zara. Tell me a little bit about this.
Yeah, so it's basically the government saying we want to go to a peppercorn ground rent on all leases, but they didn't sort of make the distinction between residential leases and commercial leases.
All right.
So they gave 5 different options, which was sort of basically completely removing ground rent, capping ground rent, freezing ground rents, and there was one other option, and the last one was none of the above. And they're basically asking what the effects would be on different groups of people. So you've got freeholders, leaseholders, mortgage lenders, and then you've got developers and the wider property market, including conveyancers.
All right, that's good.
But I don't think many conveyancers responded to the consultation. And there's lots of debates going on in Parliament at the moment about the leasehold reform. The previous version, which they were looking at estate service charges and landlords, going back to that case about landlords being able to pass on legal costs through service charges. So there's all of that going on, but what they're proposing, I think, will cause complete chaos. So and I think they're doing this as a courtesy to all the campaign groups who are going down with leasehold. Right. Which, you know, it's a great idea. It's a lovely ideal, but it's not going to happen overnight. Yeah. Whatever they do, it's got to be done incrementally, and you can't just take away a source of income without compensating. So the previous suggestions of what they were doing to make lease extensions easier, removing marriage value, and I'm not a surveyor, so something about re-looking at deferment rates and the calculations of the valuations. I said to them, look, I don't have a formula for you, but you need to look at all of that and make it a fair process to incrementally take away ground rents by those people who want it, because not everybody's going to have a lump sum to be able to pay that compensation up front. Some people will just carry on happily paying £200 a year or something like that. And we're always going to have cases where no matter how much you tell the client, this is not a good idea, they're just not going to listen.
No, that's true. Yeah. It's like someone, you've got the worst lease you can imagine, but you still have clients saying, yeah, thanks very much for telling me about that, but it's the home of my dreams, therefore I'm having it. Yeah. Thanks for that, Zara. That's really interesting. Megan, breach of freedom of contract. I agree. Yeah, it is. It's a mess, isn't it? And as I say, the thing that worries me is when the ground rent legislation came in 2022, during the consultation process, landlords were saying to the government, look, this is money that is income for us, but we use it as a sort of reserve fund in connection with service charge losses or non-payments, etc. I hadn't thought about that, but it makes perfect sense. So it could be an investment, but also it is, as I mentioned, this cushion or buffer. And if you take that away, then there's a greater risk of sort of landlord insolvency, potentially. There are greater risks where landlords are hiding that sort of income generation within service charge, and leaseholders are being penalised just as much, but it's being hidden rather than a separate payment within the lease. So, yeah, it is a problem. Zara says it also has unintended consequences with the Building Safety Act. Yeah, well, this is something, Zara, that again, I've been doing a lot of work recently with landlords about the Building Safety Act. And again, the problem that landlords have got is, one, the Building Safety Act is designed to assist leaseholders and to take some of the remediation costs for some defects out of service charge, meaning landlords either pay for it themselves, rely on government schemes, or claim from original contractors. Now, claiming from the original contractors that did the defective work is high risk. Government schemes to provide funding are not fully funded, so therefore to say I'm going to rely on a government scheme, in my view, is dangerous. So therefore you're left where you've got a building full of qualifying leaseholders, where there's a whole chunk of service charge that you're not going to be able to recover. And therefore, what do? You can't borrow money. These issues about losing ground rent, etc., mean your opportunity to borrow money is in fact reduced, and therefore logic suggests that you're looking at more and more landlord insolvencies. And it's an issue. The other thing I've got, and I've just got this on my desk with regard to the Building Safety Act, is a landlord who needs to produce a landlord certificate within 4 weeks. He's got a former landlord that he needs information from. The former landlord has 3 weeks to produce the information and isn't going to be able to produce it. So the current landlord, the landlord that has to produce the landlord certificate, now is not going to produce his landlord certificate within 4 weeks. That means that there's a presumption that the landlord meets the contribution condition, so he can't transmit remediation costs relating to relevant defects into service charge, and the landlord's saying, look, as a consequence of the lack of information from a former landlord, I can't produce a landlord certificate. I'm not going to be able to recover all these remediation costs from qualifying leaseholders, and therefore I'm stuck. And the logical consequence of this landlord's position is that, hey, I'm potentially insolvent. And then what you've got with regard to that is a situation where who ultimately is going to be liable for all of these costs? Well, the leaseholders are, aren't they? So yeah, that's service charge. Megan, no rent will also push up premiums. Yeah, it will. Definitely, Megan. Thanks for that. Okay, we'll come back to this in a moment or two. But what I'd like to do is introduce Aidan Moore from the Metro Bank. Aidan, thank you so much for coming along today and to sharing with us your experience and your views. Lovely. Aidan, your contact details are shown on the slide. First of all, if you could just introduce yourself to the audience and a little bit about Metro Bank would be brilliant, please, in the legal context, yeah?
Yeah, of course, no problem. Thank you very much. Thank you very much for having us. So, hi to everyone, and you may or may not have come across Metro Bank in the market before, whether that's acting for one of your clients or whether it's in terms of the firm's home banking. So, just to give you a bit of an idea as to who we are and why we're talking to you today, the Metro Bank was set up in the wake of the financial crisis back in 2010, so we're just coming up to close to 14 years old now. And we were set up purely on the basis of delivering a service-based proposition for our clients, where a lot of the other banks were turning towards automation or pulling away stores and whatever else it may be, or branches, I should say. So the bank has come on a long way in those 14 years, and certainly most recently we have turned a real focus towards the legal sector and supporting the clients within that. What we've really found recently is that a lot of firms have been able to take advantage of increased rates in terms of client deposits and whatever it may be. But also I think there's, broadly speaking, a lot of people who don't know about us and what we can do. And actually really the real focus of how we deliver our proposition is almost taking banking back best part of 20, 30 years, where there's actually a person to speak to. So part of why I'm here talking to you today and to show a face for that, really. But as I said, overall, the real drive of the bank is to become a community-based bank. And a lot of banks will say that in different capacities or in different factions, but actually a real core of that for us is businesses and firms that actually have a real impact on those local communities and the people that live within them.
Thanks for that, Aidan. It's quite funny you mentioned that. I was with some friends. Yes, I've got one or two friends over the weekend, and they were discussing a problem they've got with their bank. And what they said is the problem isn't the proposition. The problem is they've got no one to talk to. And that they were saying that they spent 2 weeks trying to find the person that they needed to speak to, and they just went round and round in circles. And in the end, in the event, they were saying, look, we're just giving up. We're just, it's a great proposition. We want some investment. We've just decided our bank is no good to us because we can't find the person to talk to. So I think there's a market there and a point there, Aidan, that you've touched on, certainly a nerve that you've touched on. So thanks for that. Aidan, if you don't mind, I'll ask you one or two questions if that's okay, because I think it might be of interest to people that are attending today. Yeah, what do you see are the common frustrations or issues and challenges you're seeing with law firms at the moment? Are you seeing any pictures or patterns that you'd like to share or could share with people that are attending today?
Yeah, sure. So obviously we look after a number of clients across the bank. One thing which I won't go into detail on because you already have is around the Building and Safety Act. That's clearly a frustration for the most of the sector for obvious reasons. But in terms of the actual running of these firms, I think there's a lot to be said around sort of recruitment and resourcing at the moment, finding the right people in different areas. Obviously, there's a lot of consolidation in the market as well. So there's an awful lot of change in the firms you have dealt with for a long time and where that may now be changing and people passing on their whip or whatever it may be. There's been some big challenges in terms of payment delays, as I think you may have touched on briefly earlier. A lot of people on this call likely would have been affected by the CTS outage at the back end of last year. Hopefully not too challenging, but I think overall, actually, one of the things that we are seeing predominantly and where we're being asked for help wise is the rising cost of PI insurance. That goes up every year and always has. That hasn't changed, but I think there's certainly been a bigger spike more recently. Certainly, some of the people we've spoken to for a number of different factors. So really, that's making people consider a lot more around their cash flow, and what obviously has been a bit of a turbulent last 12 months anyway in terms of property and what's coming on the market, and potentially a 3-month delay of houses not coming on or sales not being completed, things like that. So it's been a really interesting time in the conveyancing market. It certainly got quieter at the back end of last year from what we can see, and I'm sure people will speak to the same in most parts. Obviously different areas of the country affected differently, but the common factor across that and the end result really is around cash flow and how can people help manage that through that time and wait until the better times come again, really.
Yeah, thanks for that. Yeah, it is an issue, isn't it? I mean, everyone's interested from a consumer perspective in reducing the time it takes to complete property transactions. And of course, the logic is that if you're able to do that, you're reducing the amount of lockup time with regard to fees. So, it's certainly it's in the interest of practitioners to get the job done as swiftly as possible. On your PI insurance point, I'm going to get someone from Howden Insurance Brokers along to one of these presentations to talk about indemnity insurance. But I was talking to someone late last year, and they were saying that if you're a firm that does nothing but conveyancing, there are very few insurers that will insure you. In fact, I'm sure someone said there was one potentially in the market for a new firm that was set up just to do conveyancing. And of course, if that's the position, then you can do whatever you want to do with regard to risk and claims, etc. Premiums are going to go up, aren't they? They've got to. Yeah,
exactly. And I think especially out the back of that, if you've only got one potential person providing it as well, your funding options out the back of it are even more limited. So certainly as a bank for where we've sat in the market for a long time, we've done a lot of work with the SLC, and we're one of the few banks that will actually directly fund those that are members of the Society of Licensed Conveyancers rather than SRA regulated firms. And it's just those little things that I think in a more broad sense, a lot of banks need to help some of their clients with. And it's really been an interesting time to see what else we can do with that, really. Yeah,
thanks for that. Some more questions. I've got another question from Stewart. Hi, Stewart. A great friend of Stewart Title, and indeed myself, Stewart Kay. You've got a nice question. We'll come on to that in a moment or two. But I've got some more questions before that. Where do you see banks generating added value for firms? What can here's your chance to sell yourself, Aidan, and say this is what we've got, this is what we can do. So how can you give a conveyancing firm added value? What do you think you've got?
Yeah, sure. So really I'll touch back to sort of the service point that we mentioned earlier. So is, as you said, the vast majority of banks in terms of their offering is broadly similar. In terms of the actual function of how things operate, that there isn't a major difference in what those banks offer. But certainly from Metrobank's model, in terms of what that looks like, I think a lot of the people that we speak to, or certainly that I have in the last 6-12 months or so, they have been sat with another bank where they've potentially been sat in like a pooled type client relationship. So they don't have one particular contact. They may have had someone fantastic before, and we certainly know they are out there for some firms. But that person moves on and there's not the continuity or whatever it may be. So I think there's a real value to be had in how that is managed. And certainly I can speak from our perspective. We make a real point of everyone's got a relationship manager, and you also should have a secondary point of contact as well. So if for whatever reason one of those were to move on, there's always someone to continue that relationship. As you hear so many horror stories around where someone's agreed terms on funding and then their relationship manager's left, the next person's come in and said, well, I don't quite like this deal in the same way. So it is really what that continuity is a massive value add, and that even comes down to the small operational parts in terms of you take on another firm's whip and you're adding a new cashier onto the mandate. Sometimes if that can take 3 months, that makes massive operational issues. So having someone to pick up the phone to actually is a real value add. And hopefully, whilst it's a real selling point of Metro, hopefully, a number of people on this call do have that from their bank. And if they haven't, they should be asking that sort of question of who can I contact? Because there are those out there. It's just about finding the right person, hopefully at the right time. But when it comes back to that as well, I think without having that point of contact, there's other things that you don't know that you're missing out on, if that makes sense. So certainly, as we've seen the interest rates spike over the last 18 months or so, you know, the fees that people can earn on their client money that they hold can be real game changer for a lot of these firms. You know, that's a firm of any size, from a brand new firm right up to a large regional firm. You know, the client funds that help, actually, it helps pay for fee earners, it helps pay for office costs, whatever it may be. So you know, those sorts of conversations, actually, if you've got that point of contact, you know, you add that value naturally by having the right products, the right services, and helping with the cash flow items that we spoke about earlier. You know, oh, can we fund this for you? How are you managing in this type of situation? You know, when your PII comes around for renewal, you know, what's your plan? Have you got the cash to pay for it, or do you need help funding? That type of thing, really.
Yeah. On that point, are there other services that you offer that firms might not have considered? So you mentioned sort of funding for PI. Anything else that you've got? What else could you do, or what else do you do that people might not be aware of?
Yeah, sure. So there may be tax funding for partners, partner capital loans. It may even be things as company cars for directors. We will look at that. But I think probably more importantly, which is a bit different to others, is how you fund your WIP, and on a day-to-day cash flow basis. Certainly, if you're looking at the acquisition of another firm or another book, actually there's different ways that can be done rather than a standard bank loan. So it's all about that conversation. And obviously every case is slightly different, but a real nice point for myself is that we don't have a computer says no. It's really is a person that underwrites it, and a credit partnership, really, where we talk to our credit partners and what do you think of this? Could we make it work this way? And it's just a bit nicer in that sense, really. But that, I think that's the real selling point for us, is that it is people that do the work. Whether that's dealing with the client or whether that's in the background underwriting the loans or overdrafts or whatever it may be that we're looking to fund you with. It's actually a person making that decision, and it's a conversation rather than a hard no, because it doesn't tick 3 boxes out of 4, you know.
And my last question, what do you think is coming down the road with regard to banking, particularly in the sort of legal sector? And if we could focus in on the sort of conveyancing sector, do you see anything happening? Do you see any issues with regard to digital conveyancing, some of the things we've been talking about that you're aware of, or things that you're involved with?
Certainly. So you mentioned earlier around PEXA. I know that's probably not something that's going to happen overnight, but there's obviously been conversations around that, and we're aware of what that may look like in, you know, down the road for firms, in terms of what funds are held and where it's sent and so on. So that could be a real game change in any way. It could be positive, it could be negative, who knows just yet. I think in the more immediate stance, you know, changes to base rate potentially at the back end of this year. There's obviously a lot of speculation that may be the case. It may change by a small amount. It may change by nothing this year. It could all be next year, but that may restart the property market to a greater degree. But it may also, on the flip side of that, have a slightly lesser return on the client funds you hold. So it's about balance, really. And we'll is finger in the air and hope that we can just help and support people through that, really.
Thank you. And a question from Zara there. Do you see CHAPS payments going down the blockchain route? And seen anything on that, or what are your views on that? I'm sorry to throw that one at you, but we can blame Zara for that.
Thanks, Zara. No, it's a really interesting question, actually. I mean, blockchain is obviously a very secure type of background, that system that backs it up. I think it would be tough to implement across everyone very quickly. You know, down the line, I certainly wouldn't write it off. I can't say I know enough about it, to be honest with you, to make a call as to what I think will or won't happen. But I'd be amazed if it's not being explored in some capacity.
Perhaps it's something for me to have a look at for sort of future forums, etc. Before we leave, Stewart Case, he loves you and loves Metro Bank. We were just saying a little bit about sort of client concerns about some of the sort of press negativity, and
Sure.
anything happening on that front, or anything you can say to ensure that Stewart's got a message for his clients.
Yeah, absolutely. And look, thank you, Stuart. Really appreciate it. It's certainly been an interesting 6 months, to say the least. You know, I think there was a real challenge for us in the press whereby it was reported in a way that we probably don't think was necessarily fair. Obviously, I can't say too much on that basis, but you know, the bank went out into basically to raise capital for growth, and it was pitched to the market in a very different way, probably in light of everything that had happened last year with Silicon Valley and Credit Suisse. You know, there was a real sentiment towards the banking market, which created a lot of uncertainty. But you know, as you'd expect, some press stories are accurate, some are not. But you know, what we're really happy to announce out the back of it is that we raised more capital than we were originally intending to, which really shows the support of our shareholders. And that's really now geared us up for growth this year. A lot of what the really positive message out of that is that the changes that have come in as a result of that, and everything that's moved in, is all of that focus is going in towards our business and commercial customers, or a real focus of that is, and the technology that supports that as well. So, you know, whether that's more people in those areas to support people, as I said, on a face-to-face basis, but also, you know, the technology that you use on a day-to-day when you don't want to talk to your bank manager, actually just to try and push that through and make sure things are as smooth as possible. So overall, I think it's a really positive thing out the back end of it. No doubt it would have caused some concern for you on the weekend it happened, and I am sorry for that, really, because it wasn't nice. You know, it's never fun, but actually as a result, hopefully you would have seen all of the announcements that came out after it, and some of the reporting got a bit fairer, where, you know, actually as a result we're really happy with it, and now we're a very well capitalized bank, ready to go out and compete with some of the big boys a bit better.
Lovely. Good. So Stewart can keep feeding the love on that front. That's great. Megan says something. Third-party management accounts seem more likely than blockchain. Law Society approved concept. We'll have a look at that next time, I think, Megan, this idea about using blockchain. Anyway, Aidan, listen, thank you so much for coming along today and giving up your time. So anyone can just ring you or drop you a note by email if they're contemplating a change or interested in exploring a little more what you're doing or what can do for them. So that's fine, yeah?
Yeah, absolutely. Yeah, please do. As I said, contact details are there. Any questions at all, feel free to reach out, and I'll try and do my best to help. But thank you very much for having me.
Thanks, Aidan. Really appreciate your time. Thank you. Lovely. Okay, so I have a question about estate rent charges that I want to deal with. Again, it's on my topic, estate service charges. When are these deemed to be rent charges? This was a question that was put by someone to Stewart Title, and I've been asked to deal with it. So let's just have a look at this for a moment or two. Firstly, there is a very interesting article and guidance note on the Association of Residential Managing Agents website concerning estate rent charges. So do have a look at that. It's quite a useful document to provide to clients. Second thing, and importantly, with regard to estate rent charges and estate rent charge payers do not have the same protection as leaseholders do with regard to service charge. So there's no requirement with regard to producing estimates of cost. The Association of Residential Managing Agents, or ARMA, has guidance notes about estate rent charges that's useful for practitioners. Thanks, Zara. So that's the first point. The second point is, as I mentioned, this fact that as far as estate rent charges are concerned, an estate rent charge can apply in connection with both freehold and leasehold property. So it's wrong to think that if you have service charge in a lease, that service charge can't possibly be an estate rent charge. So, next point to note, government is hoping to legislate to give freeholders the same rights in connection with estate rent charges as leaseholders do with regard to service charge. So one, statutes saying that estate rent charges must be reasonable, statutes saying that has to be formal notice given with regard to payments. Next thing that I think is important, there is some case law on estate rent charges, and I'm just going to pull that up on my screen for a moment if I can, because it's an important case which highlights that estate rent charges, in order to be payable, must be reasonable. And that case was, or is, where are we? Yeah, Smith Brothers Farms against the Canwell Estate Company, 2012 case. Darren and Gemma from Legal Brokers are attending today and listening in. Thanks, Darren and Gemma. What I'm going to do, Mark, is in a future forum ask Darren and Gemma to come along, because Darren and Gemma at Legal Brokers have some very interesting products and very interesting things to talk about. So I'll bring them along. But Darren and Gemma, do put your contact details in the chat box there so that people can contact you beforehand. But you are on my list of people to come along to talk about some of the things you're doing. Meanwhile, estate rent charges, okay? The estate rent charge has to be created for the purpose of paying the rent owner for services that it provides for the benefit of the land affected by the rent charge, or for that land and other land. Okay, so the estate rent charge is valid even if it's not specifically or directly for the benefit of the land affected by the rent charge. That's the first point to note. The second important point to note is that, as I say, a lot of people think estate rent charges only apply to freehold residential developments. They don't, okay? They can apply to leasehold developments as well. Next point, estate rent charges are not capable of apportionment or redemption, unlike what I would call a historical traditional rent charge, which is capable of being bought out. Now, there are some other points that I want to make as well that I think are important. There's no direct authority that I've found to confirm that a service charge is not an estate rent charge. So all that we can do, and this is important, and if anyone's interested, I'll send you some notes on it. All we can do is rely on Section 1 of the Rent Charges Act, which defines a rent charge as an annual or periodic sum charged on or issuing out of land, except rent reserved by a lease, or any sum payable by way of interest. So it can be argued that an obligation to pay service charge is an annual or periodic sum. The thing that means it's not an estate rent charge is that it is not charged or issued out of land. And therefore, it wouldn't be an estate rent charge, but would be a service charge. Does that make sense for everyone? I'll send you some notes on this. It won't be available probably till sometime next week, but I'll send you some stuff on it. I'm going to do another webinar on rent charges and estate rent charges because they are so commonplace. So I'll keep you in the loop on that one. But in the meantime, you'll get some notes. Okay, but I'll say it again, right? It's hard to establish that a service charge is an annual or periodic sum charged on or issuing out of land as a positive obligation on its own. Okay, so service charge, the payment of expenses, etc., relating to property management is not charged or issued out of land per se. So that would be the distinction, but there isn't any case law on it as yet. Anyway, enough of that. So what I want to do now, lots of people are saying they want some information on that. We'll make sure that that's distributed for anyone that's interested. What I'd like to do is just see if anyone else has got any topics that are worthy of conversation or any burning issues that you're encountering. While I'm waiting for that, a few things. One, I repeat, these conferences that we're organising, the idea is, with Stewart Title, the main sponsor, the idea is that there will be a day's conference, morning residential, afternoon commercial, reasonable cost, including lunch. And the first ones, as I say, are Norwich, then Ashford in Kent. Then I think we're going Bristol and Birmingham. I can't remember when, but I'll send you details and send you notes. But very good value, very good speakers, and a good day out. So anyone interested, please let me know. Anyone got any burning topics at the moment? Anyone would like any topics for next time? They've got a number of people now that are wanting to come along to these events. But if you want a topic or you want someone to come along and talk to you, hey, happy to arrange it. Okay. On the Building Safety Act, just to let you know, Law Society book just about due for publishing. Law Society guidance just about due out. Hayley, anyone recommend a UK agent who deals with the sale of a property in Spain? Don't know anyone, Hayley. Anybody else got anyone? UK agent who deals with the sale of a property in Spain. Anyone started using the land registry portal for local land charges search function? Yeah, Imran, I know a lot of people using it. I find the local land charge function of the land registry quite useful because you can refresh your search for this free for the next 6 months. I think you can do it 5 times. It has come in for a bit of criticism with regard to the information from the land registry being inaccurate. That's what I've heard. I haven't actually seen. Anyone can help Imran about the land registry portal for local land charges searches? And thanks, Zara. Well, there you are, Hayley. Hayley, we've got someone that can help us on that. And no, okay. Might get someone to come along and talk about the land registry's local land charges function, because I think there's a lot more local authorities signed up for it, isn't there? Okay, Harriet as well. Thank you. That's brilliant. Okay, I'm conscious of time. That's great, Megan, really useful, because I think we've overrun. So what I'd like to do is, Robert, thank you so much indeed for coming along and organising today for us. Thank you. We haven't introduced Freddie, have we, who's now working with Robert at Stewart Title. So I think next time, Robert, we'll ask Freddie to introduce himself and explain what he's doing with regard to your firm. Is there a UK insurer offering a latent defect policy that meets the requirements of the BSA? Robert, I don't think there is. But Mr. Kelly
I'm not aware there is, Ian, no.
Yeah, no. Are the experts on that front? I think people are looking at it, but there isn't anyone actually in the market as yet. Orla, anyone dealing with high fees being charged by landlord solicitors for providing consent? Yes, Orla. Drop me a note by email. I've got some ideas, because they are administration charges that are required to be reasonable. There's guidance on the Leasehold Advisory Service website. There's case law that explains how fees are, or how administration charges should be calculated. Hi, Stuart. Robert, are you thinking of providing an indemnity to deal with the building safety? I think you've got your answer to that one, Stuart. But Stuart, watch this space, because as I say, Law Society guidance awaited. The book that we've published, the Law Society has published, that I and Tanfield Chambers has written, is available. The other thing, Stuart, is get someone from your firm to come along to that conference on the 7th of February. It's at the Royal College of Surgeons. And if you've got a problem, let me know. Catherine, CLC, no, but drop me a note and we can sort something out for you. And Sue, yeah, professional manager agents charging huge fees. Come back to me on that, Ola and Sue, and we'll talk about administration charges. Great topic for next time, actually. We'll do that. Okay. And they are looking to legislate on it. You're quite right. The other thing, Zara, is fees for replies to inquiries, which aren't administration expenses currently. That's something that's a pet subject of mine. Hey, we'll talk about that next time. Listen. Thank you so much for coming along today. Again, fabulous numbers. Just to let you know, because of the popularity of this, we do a commercial property forum, and Stewart Title sponsored that. Stewart Title have also sponsored a forum for Scottish lawyers, which again is equally popular. So grateful to you all for coming along. Massive thanks to Stewart Title as ever for organising this. Look forward to seeing you at the next one. Remember, we've got webinars that Stewart Title sponsor. We've got events organised, all sorts of things. Keep us in the loop. Orla, always a pleasure. Zara, lovely. Everyone else, thank you so much for coming along. Really appreciate your time. Sue, thanks again. Rachel, thank you for coming along. Get it in the diary for the next one and come along and fire topics while you're doing your work or while you're coming across the thing. Send me an email or send Robert an email and say, hey, I've come across this. Can we talk about it next time? Details of the Scottish Forum. Yeah, Megan, we'll get those sent across to you. Christine, always a pleasure, my friend. Thanks, everyone. See you soon. Speak soon and really appreciate it. Thoroughly enjoyed it today. It's been great as usual. Cheers, Robert. Good to hear from you. Darren and Gemma, haven't forgotten. We'll have you along to talk about some of your products, etc. Imran, thanks very much. Take care. Bye-bye, everyone. Bye-bye.